sentence. I would submit to the court 14 months for my client doesn't help society anymore than a sentence of probation with a boot camp component. I will submit that sending my client to the MDOC immediately to then go into boot camp offers society no more protection than putting them on probation and requiring a boot camp component. The boot camp offers discipline, offers...
Right away, the defense tries to steer this toward rehabilitation, arguing that boot camp and probation could fix everything. But the big question is, does structure and discipline outweigh the seriousness of what already happened?
Treatment, it requires my client...
This is a victim's rights case, and please, Ms. or whomever, please silence your phone. Mr. Rutkowski.
Your Honor, Deputy Wells and myself have talked multiple times on this case. I knew he wanted to be here at the last sentencing. I'm not sure where he was today, but we've had conversations about this circumstance and how it's affected him. I would point out to the court that I understand what Mr. Trippleson's saying, and I would equate it very similar to the use of alcohol, which you can use legally, yet if you get behind the wheel and you drive and you injure somebody, it's no excuse. And the same thing here. Even though it might have been legal to buy, he bought this stuff, he used it, and put a lot of people in fear at the campground to the point where the police were called and Deputy Wells arrived, and Deputy Wells is trying to deal with Mr. Flory, and when he's dealing with him, he's not getting, the compliance with the defendant. And in turn, the defendant had punched him, bloodied his lip. And so from that struggle, and he had to be tased by, I believe it was Sergeant Woodward when he got there. We looked at the guidelines, and
this is where the case gets intense. The prosecution lays it out clearly. This wasn't just bad judgment. The defendant caused chaos at a campground, terrified people, and even assaulted a police officer, leaving him injured and forcing officers to use a taser. At that point, this isn't just about substance use anymore, it's about public safety.
In the recommendations, I see the recommendations, although the guidelines aren't the same now, they were 19 to 5 years on count one and 19 to 4 years. They're different grids. So I would look at the idea that the recommendation made for at least count 3, which was the RO causing injury, took that into account, that it was not at the low end of the guidelines, but was somewhere in the middle of the guidelines. And we would ask to continue with that one. I mean, we know the guidelines are now 14 to 29, but we're asking the court to consider that. As far as the SAI, court's practice has been, and we would agree that it would be in this case, that if the Department of Corrections is where Mr. Flory goes, that the Department of Corrections will score him and determine whether or not SAI is appropriate. They can reach out to the court and ask for that permission. So otherwise, we'd ask you to adopt the recommendations as set forth.
The sentence here, the reason that I was involved with Mr. Flory regarding the kratom was we were in a state of flux regarding our district judge, probate judge retiring, and I could cover the courts until our new judge was selected by the governor. So that's how I got to know Mr. Flory initially, by being a part of the district court process. And at that time, there were conversations, and always the conversations are with both attorneys, where we have discussions regarding how the case is proceeding, and there was an issue regarding kratom. And this substance reminds me back in the day of the old bath salts that used to be out there years ago. And you could go to the north end of town, pick up the bath salts, and we remember how that affected not only the state and the country, but this county as well. Mr. Rutkowski has oodles of cases relative to those types of matters involving bath salts. And here, this is to the court, frankly, a new bath salt is what this is. Kratom, you can go right now in Huron County and purchase it. And it amazes me that substances like this are available, but they are available. They're not regulated in any way, shape, or form currently. Maybe they will. But it's a substitute for other substances with individuals who have substance use disorder. Mr. Flory has substance use disorder. There's no question about that. And on the night in question, if you were in the park at the time, just merely observing what was going on, I couldn't imagine how you'd feel. It was that crazy, that it was that out of control overall when you're at a campground, merely enjoying your time, and next thing you know, there's a fracas going on outside. Eventually, police arrive, knife is gone, but the knife was out earlier, and tased, assault upon a police officer. I mean, it was not a pretty sight, clearly. And so the court obviously has to address that and the behaviors of the defendant, but clearly he was under the influence of this, I'll call it a poison, is what it is. That's truly what it is. The poison led him to do some really dumb things, frankly. And I mean no disrespect, but that's exactly what happened. And we have an individual who is a high school graduate, gainfully employed, no prior felony record at all. None. He has 4 misdemeanors, 39 years of age at the time, but no prior felonies. And so at first blush, when you look at this, and wait a second. Obviously, not a wise decision to substitute, well, I guess it would be wiser than using heroin or other substances, kratom, but that was the driving force that particular night. Now, Mr. Turkelson is absolutely correct. Voluntary intoxication is not an excuse, and they concede that. However, by conceding it, they also understand, hey, look, you have to look at the entire behavior. You have to look at the entire scenario here, and the court is looking at that. That's one side of the story. Here's the other side of the story. Individuals going back to their campers in fear. Police officers getting injured. Tasers being utilized. Knives, not pointed, knives displayed. And frankly speaking, when you look at that behavior as well, one asks oneself just simply, how or why would you act that way? You're here enjoying your time with family or friends, and all of a sudden, frankly, for lack of a better phrase, all hell breaks loose. That's what happened here. And the intoxication is not an excuse or justification for it. It explains behavior, but it doesn't necessarily justify it. And here's another example of what the court has to at least consider. That is the sentencing guidelines. The court is required to at least consider the guidelines. Back in the day, they were mandatory. And absent substantial and compelling reasons to depart, you had to be within the guideline range. Now, we have case law that has just come out last week that an in guideline range sentence was remanded back to the trial court. That even though it was within the guideline range, it wasn't appropriate. Matter is going to be remanded back to the trial court in another county, and we're going to start the process all over again. So I guess when you say discretionary relative to guideline range, I guess it's clearly discretionary because, again, the new case law that's coming out is a little concerning. Now, I don't care if it's Huron County, Genesee County, Lapeer County, it doesn't matter. You have to conform your behaviors to societal norms. That's just the bottom line. And this court has been extremely consistent, at least I hope it has, relative to considering the guideline range. At first blush, I couldn't imagine if I saw the video of this. It wouldn't have been pretty. And the court could sentence to 29 months. 29 months to 5 years, at least on count 1, 29 to 4 years on count 2. But the court is balancing all that because when you consider the guidelines, you consider the terrible decisions made by the defendant, But the changes that have been happening, there's been some positivity to warrant at one point, not 29, not the midpoint, but what the court finds to be, and this is just remaining on consistency, number one, and fairness to any individual that comes before this court, is some sort of consistency that when you understand you come before this court, this is likely what's going to happen. And when I consider all that, and I consider the defendant's behaviors since then, and the guideline range now is not 19, it's 14. The court could depart lower and give 12 months in the county. Sure, it could. But under the circumstances here and the behaviors of the defendant, which I find to be not necessarily normal, however, but based upon the use of the substance, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission, placed in the commission's custody to the low end of the guidelines, 14 months, 5 years credit for 2 days served.
Now comes the balancing act. The judge acknowledges everything: the lack of prior felonies, the influence of substances, but makes one thing clear: intoxication explains behavior. It doesn't excuse it. In the end, the court lands on the low end of the guidelines, sentencing him to prison. Not the harshest option, but still a powerful message. Actions have consequences.
Just to count 1, count 2, count 3, the RNO causing injury. Again, 14 months to 4 years, credit for 2 days served. Count 6, the indecent exposure. 365 days county jail, credit for 2 days previously served. $186 in state costs will be ordered as well. Expense, he's conditioned to receive the questionnaire, form requesting the assistance of counsel, both of which must be executed under oath and filed with the court within 42